Hello, greetings. This is Erick Widman from Passage Immigration Law. Happy May to you, and we're glad you're joining us for another Wednesday afternoon, for most of you, Wednesday afternoon live Q&A, where I'm going to be answering your pressing U.S. immigration questions. We have a handful of great questions again today, so I'm going to start right from the top and jump into it. So, first question. How about a permanent resident exiting the U.S. to travel? Can I leave the U.S. without a passport if I can enter the U.S. without it? So really good question. And this is an intriguing question. Not many people know that if you're a U.S. permanent resident, you technically don't need a passport if you have your green card to get back into the United States. However, it is a bad idea to rely upon this because many CBP officers might not know this. And on a practical level, even though the US government doesn't require a passport for permanent residents to get back into the United States, the country or countries that you're traveling to likely do require a passport to get into that other country, to visit, to travel, to conduct business, and then leave. And so going through customs over there in the country you're targeting and visiting, going through the immigration process there is typically not going to be possible, and it's not going to be smooth unless you have a valid passport from your country of citizenship. And then if you do have that, which you likely will need to have, you'll be able to travel back even more smoothly to the United States. So we recommend taking the time to get your passport renewed and have that expedited so that you can have a valid passport both for when you travel outside the US and coming back in. And thankfully, if you happen to lose your passport while you're abroad, which happened to me once, you can, which we recommend, go get a new passport at your local embassy. But if you're a permanent resident, you technically don't need it to get back into the United States. So this applies to permanent residents, US permanent residents. So good question. Question number 2, can a friend who's exceeded all the requirements in a really big gap sponsor you, even if she's not related by blood? So here's a couple different ways for me. I'm not completely certain about this question, but let's consider all the possibilities. So you're wondering if someone can sponsor you. Sometimes people use the word sponsor when they really mean petition. So a family member, for example, can file a petition for another family member, or a slightly, in some cases, you could petition as a company owner for an employee. But family members can petition, which is different from sponsoring. And you use the word sponsor. So let's assume that you're referring to a financial sponsorship, which is one of the requirements for a green card application. So there's something called an affidavit of support that every green card applicant, whether through adjustment of status or if you're coming in through consular processing, is going to need to provide to the US government to show that you are meeting the minimum financial requirements to get that green card. And so a sponsor agrees to cover you, support you in the event that you can't support yourself. So you're wondering, can a friend who meets the minimum requirements, which by the way are on form I-864P, that lists the minimum requirements there for income for your sponsor. So if your friend meets the requirements, can he or she sponsor you? So yes, anyone can be an affidavit of support sponsor who is a US citizen or a permanent resident. And so there are some benevolent people out there, many friends who are willing to do this, who are not a family member. Typically, it is a family member who signs up and makes this important commitment to sponsor the immigrant on this affidavit of support. But you could have a friend do it. You could have a friend of a friend do it, but that person has to be a U.S. citizen or a permanent resident, and they've got to exceed the minimum requirements, 125% of the poverty line. And that's what that 864P is in Paul, P is in poverty, technically. That's what that form is referring to, above the poverty line, so you can sponsor someone. The more people you sponsor, however, is the equivalent of having more people in your household. And so the dollar amount that you can sponsor decreases. The number of people you can sponsor decreases the more people in your family or the more people you sponsor as a 864 signatory. Okay, next question. Hi, Eric. I am just at the U.S. citizenship. I think you mean you just got U.S. citizenship through the naturalization process. So is it the N600 that I need to file for my child who's under 18 years old? Congratulations. That's wonderful that you became a citizen. It's one of my favorite events in life, is to participate with my clients at these naturalization ceremonies, to hear about others naturalizing. It's a huge step forward. One of my proudest days was when my wife naturalized, and she's now a dual citizen of the US and Hungary. So we love naturalization. You love it too, because you have at least one child who's under 18, and you're wondering, is your child going to be able to benefit from automatic derivation of citizenship? So yes, thanks to the Child Citizenship Act of the year 2000, for those of you who fall into this category, you have a child who's under 18, you naturalize, and your child automatically, yes, becomes a U.S. citizen, derives citizenship, but you will definitely want to file for a certificate of citizenship for your child, because that proof is key. If someone ever questions, or the government ever questions, you have to prove to CBP at the border, if they don't have a passport or something along those lines, you want to have a certificate of citizenship to prove your child's status. It's a gift that your child will have his or her entire life. You only need to get one of these once. So that is done by filing form N600, as you note, and it's kind of expensive, but the investment is worth it. I think they raised the price to around $1,500. So it's pricey, but you get that proof, which is more permanent than a passport that expires, because a US passport has to be renewed and the certificate of citizenship does not. And just to confirm what the criteria are for automatic derivation of citizenship for your child, I pulled up the stages, the criteria for the Child Citizenship Act of 2000. So you've got to have, number one, have at least one U.S. citizen parent by birth or naturalization. So your child has to meet all these criteria. Be admitted to the U.S. as an immigrant for lawful permanent residence. So your child has to be here as a permanent resident. After admission to the U.S., reside in the country in the legal and physical custody of the U.S. citizen parent. So if a permanent resident child was living with a parent who was not the citizen for whatever reason, whether it's divorce or otherwise, that doesn't qualify. Then finally, if the child is adopted, his or her adoption must be full and final, so that the adoption process is legally complete and fully recognized in the U.S. state. And adoption is tricky and difficult. I have a younger adopted brother, and my parents went through that process with him. It's absolutely worth it. It is a huge amount of work, though, and state requirements are different, various international treaties, and all these other requirements. So if you had adopted your child, make sure those criteria are met as well. Full and final adoption. Then our last question for today is a tricky one. So here's the complex question. I'm a U.S. citizen, and my parents took me out of the U.S. at 5 years old, and I never came back. I got married and have a child, and we moved 4 years ago to the USA. And can I petition for my husband and my son, who only have tourist visas, or is my son already derived citizenship? So these questions are a little bit similar in that the Child Citizenship Act could be involved. It's not going to be possible for me to give you a definitive answer because I need more details about your case so I can look at the corresponding charts, which are also kind of complex. But lawyers have access to these. There are no doubt some of these online for anyone to look at. But what I would encourage you to do is email us, support@passage.law, give us more details, and myself or another attorney will be able to give you an answer. But one of the key things that you've got to keep in mind is the rules changed after the year 2000. And so the Child Citizenship Act of 2000 makes it a little easier and more streamlined when you naturalize and your child, like I described earlier, can automatically derive citizenship. But I'm suspecting you are not that young, and so the rules are going to be different based upon your date of birth and what year it was when you were born and when you left the U.S. Because you noted that you never came back so far, but you got married and you have a child, and so maybe you do say you came back to the U.S. 4 years ago. You petitioned for your husband. But has your child already derived citizenship? It is complex. And at this point, we just don't know without more information from you. But one of our favorite cases very recently was a British man who was living in the UK. And we thought, before we fully investigated his case, that his brother's company would need to petition for him and get a green card through business-based pathway, which is pretty challenging. After looking at the details of his case and finding out the history of his parents, we realized he qualified for citizenship. He was already a U.S. citizenship through derivation. And it was wonderful because he simply had to apply for an N-600 rather than taking all these other steps to get a green card or a H-1B visa. Therefore, if you suspect that you might have already acquired or derived citizenship somehow, definitely look into it, because then you can just file the N-600 and you're done. You prove your citizenship to USCIS. Let's see. Okay, got a question came in. Let's see if I can look at this late breaking question. I applied for a 485 on July 1st in the F2B category. She will apply for naturalization. If she is a citizen before I get my card, will we have to transfer my case to F1? It will delay my case. Okay, so you are adjusting status. That means you're in the US, and it looks like your wife petitioned for you. I'm guessing that. Use the word she. But your wife is naturalizing. And if she is a citizen before I get my card, will we have to transfer the case to the F1 category? That's one of the preference categories. But interesting. So F2B, F1. So whether it's your mom or your wife, when you have a petitioner who's naturalizing, oh, thank you, sir. Your mom petitioned for you. So your petitioner can, if she naturalizes, you can choose or not. Your mom could choose or not to upgrade the petition. Sometimes it's not a good idea, like in your instance, where it would slow it down. But thankfully, USCIS allows you to choose to apply that upgraded petition or not. So in your instance, it would not help. So you would simply let USCIS know that you don't want that category change, the preference category to be changed. So you're gonna be fine, and it's not an automatic thing. You're in control of whether that upgrade affects your petition category or not. Okay, next question. We've got some late breaking live ones. Can I get refugee status to stay permanently after coming in via the recent Uniting for Ukraine program? So we've been reading a lot about this, and the government is still finalizing things. I know there's supposed to be an adjustment act, both for Afghans and hopefully for Ukrainians and so many others. So you came into the US already on probably, you mentioned the Uniting for Ukraine program. Personally, I am not aware of a special way to get a green card, but yes, you can absolutely apply for asylum. And that is the equivalent of being a refugee. It's the same, very similar legal standard. And so since you're already here, you don't need to apply for refugee status. You might be, maybe you're not in the US. Maybe you're wondering, hypothetically, could you then apply after you entered in? So, okay, cool. Look at this. You are waiting and you apply. But yes, once you're here, just like many of our Afghan friends, they're brought into the US, maybe through humanitarian parole, through one of these other programs. It's understood that people are going to want to apply for something else. And that's what we've been doing with many of our humanitarian parole clients, is applying for asylum and showing. It doesn't mean you're automatically going to win your case. You're going to have to show that you were persecuted in the past, or you fear future persecution on one of these protected categories: race, religion, particular social group, and political opinion. Those kinds of categories are, you're going to have to prove your case. So in many ways, that can be tougher for Ukrainians than Afghans, for example. It all depends, though. Certainly, I read that certain categories of applicants from the Ukraine, you have a stronger case in that if it's a certain type of religious persecution. So it can get complex, but best of luck to you. Stay safe out there for sure. We have come to the end of our live Q&A. Thank you for tuning in. We look forward to joining you next week. Go ahead and email us your questions in the meantime, and I'll address them next week. Take care.